Okay, hi everybody. Uh, Thank you for coming to this studio again. It's Ray Teo, Senior Commercial Agent in Canada, IQI Canada, and today we are very lucky to have Mr. Marcelo Sarkis, Senior Patent Agent, who is here with me. Hello, Mr. Sarkis.
Hello, everyone. Happy New Year.
Yeah, talking about that is Chinese Lunar New Year, the number 8 day actually. And Canada, we do celebrate Chinese New Year as well. So it's the same as Asia, anywhere. We have 15 days of uh, season, holiday season actually. Some of them actually don't work till 2 weeks, but they work all year round. So again,
Good two
Canada,
weeks
we have
off.
no holidays.
Yeah, good 2 weeks holiday.
hmm So yeah, Mr. Sakis, so great that grateful that you are here. So people usually don't know what this patent right. They don't know about their copyright or what is their trademarks. I see a lot of them in trademarks. A lot of stuff that is trademarked and marked down. What are the usage? Can you explain a little bit so that people in Canada as well as globally, I think they are all almost the same wherever you go, right?
Similar. Thank you again, Mr. Teo, for having me today and for allowing me to share about intellectual property and the what is intellectual property, as well as what are the benefits of intellectual property for your business. As most of us know, we know what is real property, real
Yeah,
estate.
that's
This
what
is
we are
real
dealing with.
property.
Yeah, real property, but
And so there's
intellectual. Mhm.
intellectual property. And so intellectual property deals with your ideas and your proprietary knowledge and information,
Mhm.
including patents, which would cover, for example, an invention and the functional aspects of an invention. A trademark would cover the name, the brand or logo or slogan of your product. A copyright would protect the literary work or artistic work of an author or an artist. And the industrial design, which is called industrial design in most countries, in the United States, it's called a design patent. It protects the aesthetic look or aesthetic features, the look and feel of a product. So, for example, I have here just what I typically show. I have here two flashlights. If you can see, two
Yes, yes.
flashlights.
hmm
They both have different functions. So the functional aspect would be covered by the patent, utility patent. But they have a different shape, different look.
Yes.
This would be covered by the industrial design, right?
Okay.
Now they have a different name. So this one has a name, I think it's Snap On. And this
Okay.
one has a name, I think it's Mastercraft.
hmm
This will be covered by the trademark, right?
Oh.
Now, if there is a website or an insert that comes with the when you purchase the flashlight, for example, the instructions, maintenance, how to change the battery, all this literary work will be covered by copyright. So,
Wow.
intellectual property will help you protect your creative ideas, your creative assets, I'd like to say, and also assist you in enforcing your creative assets if there is an infringer that, for let's say they were using, let's say you had a company, Mr. T.O., and you called it Mr. Tio's tea emporium, for
Mhm.
example, and you register this as a trademark, and now someone starts to copy your name, and maybe they say Mr. T Emporium. It's too close to Mr. Tio and Mr. T. It is causing confusion that the
Mhm.
consumer is going to say, I think it's the same company. And this is what a trademark is there to protect. And for a patent, let's say you came up with a way to roast the tea leaves in such a manner that when you prepare the tea, it brings out the maximum flavor in the tea. This process, this roasting process, if no one has ever done it before, you can secure through a patent. Okay.
Okay. Wow.
So that's just a general overview of what is intellectual property, what are patents, trademarks, copyrights, industrial designs.
So, wow, that's a very good introduction that we cover most of the stuff that you talk about. You're talking about patent, trademarks, and copyright. So I have to tell my daughter when she's an artist, she did a lot of nice thing. I should tell her to get her copyright. All right. So
So
every time,
absolutely. So the instruments, for example, a patent, you have to file to get a patent.
you're right.
A trademark, you have to file to get a registered trademark.
Okay.
An industrial design, you have to file to get a registered design. Copyright, copyright is inherent to the author or to the artist. So if your daughter is creating some art sketches or some other art work,
Mm-hmm.
she can just put on the bottom copyright 2022, her name, and this is will be recognized. There
Oh,
is the other option that you can register your copyright with the Copyright Office, and then you will at least have a record of registration. Should you ever have to go into court to prove your copyright, or if you're looking to sell your copyright, you then can show you have a certificate from the Copyright Office. So,
wow. Okay, that's nice to know because she was hired by American company to do some kind of a pattern or no a logo for the company on the site on the internet, and she get paid by the hour to do it, and she did pretty good job for the company. I was just shocked. I said, hey, that was pretty good, and then she estimated and she did some work for a few hours and then she made like $100 by setting up some kind of a logo for the company. And I figure I say, well, what about yeah, like you say, copyright, right? I said, did you sign off and everything
mm,
from there that the company can actually use this for their products or their thing?
yes,
So
that's a very important point you raise, Mr. Teo.
mhm,
For copyright artists, the copyright is owned by the artist unless they assign the rights to another party. So perhaps this company, when they retained your daughter
mhm,
to do some of these projects, there would have been some sort of a written agreement where she would have assigned her rights over to the company so they can then legally use her work. What
without
is important also with copyright is there should be a waiver of moral rights. If you are on the side of the company, you want to make sure that the artist waives any moral rights to allow the company now to modify the artistic work. So you can see behind me, I have my company logo. Let's
mhm,
say, for example, I had somebody create this logo for me and I purchased it from them, but then I start to play with the height and length and the font. If I do not have that waiver of moral rights, I could be in some issue with the artist because you need to have that waiver to give you the freedom to do what you want with the logo.
I
So
see.
it can be quite complicated, especially when it comes to ownership, not only for copyright, but for patents, industrial designs, and trademarks, which is always important then to have the proper documentation beforehand to ensure that you are mitigating any potential issues down the road.
Wow. Okay. Yeah, that's really nice to know. Thank you, Mr. Sakis. When we talk about it, how long have you been doing this, Sakis? Give me a little bit of history about yourself.
Thank you. So,
Where you
we,
from, and
we,
how long you been here?
thank you. Our family came from Brazil in 1966. We
Wow.
arrived in Canada. So we've been here since 1966. And I studied here in Canada,
Mhm.
engineering, chemical engineering. And then I entered into the intellectual property field. My last year of university, there was a firm, a law firm, seeking a chemical engineering student to assist with their pharmaceutical clients because they did not understand the chemical nomenclature. And so I was able to apply for the position. I got the position. It was a summer job. And so a summer job at a firm has now evolved into my career of 35 years and having my own patent agency. So I've been doing this for almost 35 years.
So now you don't have to mess around with the chemical engineers and
That's correct.
this and
Just
that.
mess around with the papers, right?
Yeah. Wow, what a difference. Hmm.
It's a very good field for anyone who's interested in, who has a background in engineering or science. Many firms around the world are always looking for high level engineers or scientists to assist on the technical side of intellectual property because you need to understand not only the technical aspects, but you also need to have a sound understanding of the law, the patent law, because it's quite important. You are drafting a document to protect a product that a client is selling. And if that document is not drafted properly, it could result in competitors coming in and knocking off or copycatting the product and avoiding the patent. So it's very important to be able to consult with a patent agent who has that knowledge and ability.
Wow, that's nice to. What about some people? Even though when they created something in overseas, can that be patent over here in Canada?
Yes, absolutely. So the intellectual property system is quite global. For example, with the PCT, which is the Patent Cooperation Treaty, there are over 152 countries that are part of the PCT. So you could file your first patent application in, let's say, Japan, for example, and within a year, you then can file in other countries, and the other countries will respect the filing date that you had in Japan. So you don't need to file all at once because the expense can be quite significant, but you can file in one country and there are strategies to use. So you could file in Japan and then you could then from that filing you could seek an international filing which then converts that 1 year to actually 30 months. So now you have 2.5 years to test the market, to find your global distributors, to find your global partners before you decide, okay, this product is doing very well in the United States in the 2.5 years that you were looking at. Then you can say, okay, I want to also protect in in the U.S. Unfortunately, Mr. Teo, I sometimes get clients who have been selling a product for maybe 5, 6 years, and then they say, wow, this is doing really well. and then they call me and they say, I want to protect this with a patent.
Okay.
Unfortunately, the patent laws are, and this is most countries, you have 1 year from public disclosure to seek protection of your invention. If you pass that 1 year, you have basically given that to the general public in the sense that someone could now replicate it and you would not have any patent to assert against them. So it's quite important early on in your R&D stage that you consult with a patent agent. And most patent agents will do some preliminary consultation at no charge, at no expense, because most patent agents are wanting to help uh, the businesses or the individuals and guide them on the right path so they can secure their intellectual property. So it's very important. Basically, do not tell your neighbor, do not tell your colleagues you have a great idea before you speak with a patent agent so they can tell you what are the steps required so you don't jeopardize your intellectual property.
Wow. How do you find out whether the product has been patented or not? So,
So what we do is we have searchers, patent searchers,
uh-huh.
that a client will come to us and will provide us with we will ask them to complete an invention information form. Any discussion between the client and us is confidential and is privileged. When they provide us with that information, we then ask our patent searcher to conduct a search. And they will do a search of the publicly available databases and provide us with a general idea of what has been patented or what has been disclosed within the collection, public collection available. We then assess those references to determine whether there is at least a portion of the client's invention that could obtain patent protection. In some cases, the search results are a bit disappointing to the client because we may have found the exact invention that they're wanting to protect. But what I tell my clients is do not look at it as a negative, but rather use the information that you have now found, that we have found for you, to further improve and develop your product to something better that you then can seek patent protection.
I see. Yeah. So that's really important within the year because I do sometimes I find some products here already exist in North America, and then when I go back to Asia, they don't have the product there. So I
Yeah.
notice, I say, hey, it's a good idea to whatever they have here. And then if I were to bring it over there, so I need to check their patent right, even it's from overseas, right?
Yeah, the patent rights. But the other thing too is, let's say you see a product here
Mm-hmm.
and then you go to Asia and it's not there. You could still patent a product in Asia if you change the product that you have seen here
Right.
and you change it enough that it would now present a
Your own.
patentable element that
Ah,
differentiates from the prior art. For example, let me bring up my
flashlight.
example, my two flashlights, right?
Yeah.
So the red one is fixed. There is no, it's a fixed length.
Okay.
It does not move. The black one allows you to extend. It's telescopic.
Okay.
So there's a difference right there. And a
Right.
telescopic also alters the focal length, right, of the
Right.
light. So it can concentrate or widen the beam. This
Right.
could be considered as a patentable improvement over this one. So maybe you saw this here
Right.
in Canada, and then you went to Asia and you want to protect it, but then you added this component.
Oh, okay.
Then you can protect it, right?
Mm-hmm.
But if you take this and you take it to Asia, it's the same thing. you might actually be able to protect it because the patent office may not know of this. They may not
Mm-hmm.
be able to find it. But if you are ever in litigation and you're trying to assert your patent rights, the other side will do their research and they may find this and invalidate your patent. So you have to be careful.
Oh, I see. Okay. Yeah. Just so curious because of this is more advanced country. When you go back there, they don't have certain things over there. And again, maybe the product will not reach there because of the currency difference. Because
Yes,
uh, so a lot of stuff are coming. They patent here, but they made it in Asia and then they ship it over back here, right? Because of the cost difference.
a cost difference. Yeah.
Yeah, so that's why I was just curious, like, wow, certain things that people use like daily product, right? It would be a good advantage to have something over there when they can get it there and maybe produce over there. But some are made in North America. And
Yeah,
of course,
absolutely. And we advise our clients, you should, when you're looking to protect your invention,
mhm.
you should not only look at the consumer market, meaning which country or which region will
Oh,
be acquiring your product, but you also want to look at the jurisdiction where it will be manufactured, because
oh,
you want to have that protection in the country where it's being manufactured to prevent other manufacturers to copy and then try to export into the country of your consumer base. And if you have a patent in the consumer based country, you can then assert infringement in that country. And in some instances, you can seek an injunction to block any product entry into the country where you have patent protection through the courts. So this is why it's important to, you don't necessarily have to patent in 152 countries. So for example, if you created an ice skate for ice skating, maybe you don't want to seek protection in Brazil because it's even though there are some indoor rinks, its skating is not as popular as it is in northern hemisphere countries. So
right.
I always tell the client to think about this because it can be quite expensive at the end of the day, and I would rather they focus and strategize on the budget for seeking intellectual property protection, and then the rest of the budget can be for marketing or product development, etc., as opposed to putting all your budget into being a patent rich company, but now you have no funds for marketing or R&D, etc., right?
Wow. Okay. Yeah, it's very good to know. And what about the intellectual property or IP? They call it, right? So, is there a time limit for this patent? Let's say if I patent it, does it mean that it expire in 5 years or 10 years?
Yes, yes. So depending on different countries, each instrument has their own expiry date. So for example, a patent, a utility patent is has a life of 20 years from the filing date, from the earliest filing date. That's standard, right? For example, in Canada, an industrial design has a, now that they have extended the life, has a life of 15 years, and in the US it's 14 years. So every country is different. For copyright, I believe it's the life of the author. So if the author lived 50, 80 years old, plus another 50 years.
Oh,
So you can maybe recall a few years ago, there was a lot of news stories about Happy Birthday song was now part of the public domain because it had expired the copyright protection. So those are things that you need to look at as well. And for a patent, when I say 20 years from the filing date, that is only if the patent holder pays the annual fees required by the patent office to maintain the patent.
So
in
there's
force.
a yearly cost to pay.
Most countries, it is a yearly cost. Most countries, it is an annuity. In the United States, it's not every year, but it's at 3.5 years, 7.5 years, and 12.5 years. But the fee that they charge more or less works out to whatever fee you're going to pay if you're paying annually. And this is
Mhm.
important because sometimes clients don't appreciate that. And the government set this up to say, in my view, if you're successful with this patent and it is generating revenue, then you will want to pay that annuity. But if there is no market and you're not finding any success with this product, you will not pay the annuity and you will let it lapse. And then it will go into the public domain, meaning anyone could then use that
I see. Wow.
invention and that patent.
Mm, okay, that's really important to know. So some people they say, "Hey, I've been using this, register this patent for 5 years now. Nobody's gonna copy mine. Just forget it. I'm gonna save the fee, right? Probably it might not be making money after 5 years or something because it's so common now, right? Everybody is getting them.
Well, but
So
the thing is, too, Mr. Teo, is many times what inventors will do is they'll come up with an invention and they'll get it patented, but then they use that patent as an asset. So now they can offer that asset for sale, just like real
okay,
property. So
okay,
let's say maybe you came up with I don't know, you came up with a new remember they had the Sony Walkman, right? For
yeah,
many years. So now you came up with a new design that it's all digital, or maybe it's not even digital. Maybe it's you put your sunglasses, it's now part of your sunglasses, and you can get from Bluetooth from your car or from wherever, you
uh-huh.
could then sell it to Sony, right?
Mhm.
It's an asset, and there will be a valuation, just like in real estate property, there'll be a valuation determining based on demand, right? Based on how old is this patent, how many years does it have left. So similar exercises to determine the value of intellectual property is similar to what is done with real property.
Hmm. Yeah, that's a really interesting things to know, right? Especially when people that tries to go back to Asia and then they come here and they think something is good idea that they brought in. So
If they modify it a bit, then sometimes what we see is we say, yeah, we can try to file a patent for it as long as there's some modification, not just on a utility patent, but also on a design patent as well, right? If they come up with like I was talking about the two flashlights, they
right.
look different, right? So if you can make it look a little different, and you can try to secure protection.
Wow. So okay. So people can take my product and add stuff in it, so the pattern will go off. So that's why
If
you gotta keep an R&D area to improve your product if it's
Yes,
doing well.
yes, and again, the difference, if you improve on it, it has to meet three basic tests for a patent. First of all, it has to be new, meaning no one has ever done it before. Second of all, it has to be inventive. It cannot be obvious. So let's say you replace a nail with a screw.
Right,
That could be considered obvious because you say, hey, if I use a screw, when I fasten the two members together, they are staying fastened together for a longer period of time versus a nail.
right.
That would be considered obvious. So you don't want it to be obvious. There has to be some inventive step. And the third is it has to have utility. There has to be useful, right, for a patent. So any improvement that you come up with, at least from a patent side, has to meet at least those three tests.
Wow. Okay, that's nice to know. Um, as a people that now they have a differentiate between the industrial, like people who makes product. See, if they take the product here and then they twist a little bit, they can actually make a trademark for it, right?
Or an industrial design if they're
The
changing the
industrial
shape.
design, yeah, to change
Changing the
it to
shape
make
would be
it
an industrial design.
to
Yes, for
make
sure.
it more what do you call that better, to improve that those basic thing, they still can have a trademark on it,
Yeah,
especially
or
engineers
or industrial design, right? Not a trademark. The trademark would be for the name.
or
But let's
industrial
say
design.
for,
Yeah,
for example, there's
the
two different
mouse.
mouse, right?
Yeah, yeah.
Their shape is different.
Mm-hmm.
Their shape is different, so they would have a different industrial design for that.
Uh-huh. I
Yeah,
see.
wait, I forgot which one. Oh, that's one. But the name would be a trademark, right? So if you came up with a new name, it would be a trademark.
Okay, excellent. Okay, for the patent, copyright, industrial stuff, all these things are really, really informative. Well, so what?
If you are, let's say, bringing your business, for example, from Asia to another country, or even from Canada to a different country, it's important to look at your intellectual property assets. That's one thing that I would strongly urge anyone looking to bring their business over, either outbound or inbound, to always look at the intellectual property um, side of things before they make the final decision.
So yeah, so I would advise that anybody who's bring new products into the country, they should actually seek your assistance from there, or they try to manufacture something here, right?
Yes,
So
and we have a network, a global network,
mhm.
where I work with associates in different countries for many years. In my 35 years, I've built a very good network. So if they have any query or question regarding, let's say, Vietnam, we have people there that will understand clearly what is the law in Vietnam, or even in the US or in Mexico, or wherever. We have that network.
So different countries have different patent right.
Yes, different
Rules.
intellectual property laws for sure.
Okay, yeah, that's very nice to know. Okay, I think today, any last word for our viewer out there, Mr. Sakis?
I just want to again thank you, Mr. Teal, and the organization for hosting me. I think this is a great thing that you are doing and offering. IQI Global is a big, big company, and they don't forget, which is what I like to see, to help people and to have these informative sessions, particularly when it comes to people's livelihood and their lifestyle. There are so many things that we need to think about. And this is a great way, especially during these pandemic times, to provide information to all your clients and your followers. So thank you very much, Mr. Teo. Thank you so much.
Yes, and I believe that with because this uh, broadcast, actually we have 3 million viewers daily
Wow.
on this July IQI. So what happened is that people are seeking information today and they don't know where to go sometimes. So and then to know some of this information, they can click on our site, ask for Canadian patent right. So and you see they have your information, your name will be on this banner running, and your phone number, your email, and your website. If any viewer are seeking for information, you can contact Mr. Sakis directly, or you can call me. That we can give you more information through Mr. Sakis, and that way, or you can contact him directly. So with this information, I hope will help all the audience. And again, people coming to new immigrant or people here, not only immigrant, anybody, right? Or this kind of rights we don't know, copyright, patent right, and all these we could be also seeking. Maybe we're doing something that is we didn't protect ourselves. Now, if we invent something or we started something, ideas is very, very important to protect ourselves. Okay,
Yes,
thank
very
you.
true.
Yeah, thank you, Mr. Sakis. Thank you
Thank
for your
you,
time.
Mr.
And
Teo. Thank
then,
you so much.
yes, okay, bye bye. So for now, we'll see
Bye.
you next time. Hopefully, we'll get Mr. Sakis back after we have more information. Thank
Thank you.
you.
It'll be my